So my name is Sophie Carter, and I head up the Family Justice Practice team for the Centre for Justice Innovation. And I'm absolutely delighted to be joined today by Judicial, Associate Director at the Nuffield Family Justice Observatory, Her Honour Judge Carol Berger, and His Honour Judge Matthew Entwistle. And they will be speaking to the development of the toolkit and their practice experiences of writing to children as well. I should just say, though, for those of you who are a little less familiar with the centre, just a quick introduction about ourselves as well, as we're still letting people in. We're a not-for-profit organisation that fundamentally seeks to build a justice system that's considered fair and effective. We believe our justice system should be focused on solving the issues that drive the difficulties families are facing, and it should be fair and experienced as fair in how it treats people and those coming through that system. As an organisation, we deliver a range of work to help us reach that vision. This includes hands-on work with practitioners, teams, local authorities. We also conduct research into how things work now, how they could work better in the future. And we also promote evidence-based innovative justice policy reforms as well. So that's one arm of our work. Today's session as an Expert Voices seminar is one part of the approach that we take and part of probably a much wider programme of work that we do at the centre to really promote the voices and experiences of families, practitioners, academics, whoever is central to this work and who is leading and involved in addressing those crucial issues across our justice system. So these events are free, they're open to absolutely everyone. We're aiming for them to be as accessible to people as possible, regardless of the range of backgrounds, prior understanding or experiences. So if you are interested in any of the others that we have run, we've covered a range of topics across all the justice systems, and they're available to watch on our YouTube channel as well. And a link to today's one will be sent out to all of those who've signed up to join today following the session. So without any further ado, I'm going to hand over to Jude. Thank you so much indeed.
Thank you so much for having me, Sophie. As Sophie said, my name's Jude Eyre, and I'm one of the Associate Directors at the Nuffield Family Justice Observatory. And I'm really pleased to be here today talking about the Toolkit for Judges. I'm going to give a bit of an overview of how the Toolkit came to be and what it includes, and then I will hand over to the judges for their real-life experience and immense judicial wisdom on the topic. But before I go any further, I want to say a quick word about authorship. If you look at the toolkit, you'll see there are two logos on the bottom of it. The first is that of the President of the Family Division, which represents the judicial input and leadership on this project. And the second is that of the Family Justice Young People's Board, alongside it as an equal partner. They represent the 21 young people who fed into the development of this toolkit from the Family Justice Young People's Board, from the In-Care Councils in Somerset, and from Barnardo's Cymru. That partnership between the judiciary and children and young people is really central to what this toolkit is about, because it speaks to the direct relationship between judges and the children in the cases before them. And the toolkit for judges is about writing to children within that context. So you'll hear more from the judiciary about their perspectives on this, but I thought I would start by sharing the Family Justice Young People's Board introducing the toolkit in the words at the forward that is in the published version.
We hope this toolkit will help more judges feel confident in writing to children and young people. We've given our time and energy to this project because we want children and young people involved with the family courts to have what we didn't have but really needed.
The decisions the family court make are a big deal. They can last forever, even if the decision made seems routine to a judge. Our whole life and future is affected by it. These letters give judges a chance to explain the reasoning behind their decisions and show they care.
When everything is high pressure and high emotion, it can be really hard to remember things. We think having a letter to look back on could really help children and young people to understand what happened and move forwards with their lives.
Remember, these letters don't have to be perfect. Something is better than nothing. Making an effort to get the small details right and treat us as individuals, and that will make a huge difference to us. We want you to get this right, and we have every confidence you can.
And I'd really encourage people to read that forward, side by side by Sir Andrew McFarlane's forward in the toolkit itself, because I think they really give a good sense of the perspectives of both the judicial element of this and the children and young people's views. But taking a step back, I said I'd explain a bit about the evidence base that this toolkit is based on. And it draws from a wide range of studies from over many decades and a wide range of jurisdictions, where it's been found that children feeling heard and understood within proceedings makes a big difference to children's experiences. And that's both at the time of proceedings and as they move forwards with their lives. When children describe positive experiences of proceedings, of feeling like they were heard and understood, they're more likely to describe a positive experience and feeling positive about their decision that was made, even in situations where that isn't the decision that they would have asked for. But when they don't feel heard, or they felt like they didn't understand what was going on, we see that associated with an increase in their distress, uncertainty and confusion. And that, of course, is happening at a time that can already be very difficult within their lives. Now, each child's journey will be different. They are all unique, but too frequently in the studies in both public and private law, we hear children describing that they didn't feel like they were really seen or heard by the court. So if you can go to the next slide, Sophie. So next we're going to hear from Caitlin, and Caitlin was a young person who helped develop a research study that is cited and referenced within the toolkit, and here she is describing her own experience of family court proceedings.
You are just like a case and you're 1 of thousands. It's like you're a number on a piece of paper, that your feelings aren't really taken into account. They just see the case and they see what needs to be done and what boxes need to be ticked. You're no longer a person. You're not even a number, you're a piece of paper. And I think that's the hardest part.
Can we move on to the next slide? Thank you. So what comes out from the evidence is that as a system, as professionals, how we behave does really impact on children's experiences. We can deliver family justice in ways which decrease the likelihood of children and young people describing the feelings that Caitlin is describing there. And one of the things that the research highlights as potentially really important with that is ensuring that children and young people receive some feedback on what has been decided and why, and how their views and thoughts and feelings were taken into account within that decision making. The failure of the court to explain what has been decided and why has been found to be a significant factor in children's perceptions that their views and experiences were not being taken into account. And the research also goes on to explore the unique role of judges in this as the ultimate decision maker, as the person who knows best how a child was heard, how that was taken into account, and how that was balanced with all the other things that were going on in that situation. So if we could have the next slide, please. The children and judges and the wide range of other professionals who fed into the toolkit reflected on that evidence base that I've been speaking to, and also their own experiences of children's participation in family court proceedings. They talked about a wide range of ways that children and young people could be involved in proceedings, how they could be heard, and how they could be kept informed of what is going on. They described a wide range of ways that judges could provide feedback, different methods and models, and the need to tailor that response to the individual needs of the child. In terms of judges writing to children, they spoke about different circumstances in which this could be helpful. And to explore that a bit further, the toolkit talks about 4 possible purposes that these letters could fulfill. Now, this isn't an exhaustive list, but it is aimed at being a way in which judges can think about what a letter is trying to achieve, or another form of writing is trying to achieve when they are writing it. So I'm going to briefly speak to each one, and I'm hoping that we might have some sound as well, so you can hear from some young people and other experts. Can we have the next slide?
It would be so helpful to have a concrete, factual version of what actually happened, not warped by time or other people's opinions.
One of the things that children often do when there are gaps is in fact we all do it, is we tend to fill in the gaps ourselves. We tend to speculate, and sometimes the thing that we fill in the gaps with may even be worse than the reality. So in general, reality is better.
So those quotes refer to the first purpose. Sorry, can you just take it back one? Thank you. That first purpose, that children really talking about that, the very basics of needing to understand what happened and why. Children, young people talked about how this information is often filtered through the adults in their life, and that this is in terms of both family and the professionals that might be around them. The potential risks of this were identified as being the fact that sometimes the adults around them, particularly family members, actually don't really understand exactly themselves what was decided and why, in what can be quite confusing family court proceedings. And also the acknowledgement that everybody involved in the case has their own feelings about what has happened, and that this can influence what is shared with children. In the discussion about the development of the toolkit, the professionals shared that these are often very difficult cases, and that there can sometimes be a worry about sharing information that might be distressing or cause upset to children. But as you heard Dr. Webb describing there, a theme that was really in keeping with the input from the other psychologists, social workers, and young people who fed into this toolkit was the idea that if you don't give children and young people some explanation, they end up in this process of trying to fill in the gaps themselves. And as Dr. Webb explained, that sometimes the explanations they come up with can be worse than the reality. So thinking that not providing the explanation is avoiding that upset and distress is perhaps misplaced, and that letters are a really good way of disrupting that process and giving something factual, as the young person described there, not warped by time or other people's opinions. Can we have the next slide, please? So this is the second element, and that is really thinking about supporting children to feel like they were heard, considered important and valued by the court. And you can see here a quote from a judge who fed into the toolkit, talking about how for a child getting a letter from the judge may be almost as important as the content itself. It lets them know that the judge was thinking about them. Very similarly, some feedback to a judge from a CAFCAS manager in a situation where a judge had written to a child talking about the complex web of emotions that can come with the final decision, and how a letter in that case had supported a child to feel that he was part of proceedings and valued. So this is really tapping into what the psychologists described as part of the process of validating the child's experiences of what is happening and going on. And also, you might remember the children and young people when they were narrating their forward saying, this is your opportunity to show us that you care. And that really being very important as the antidote to what you heard Caitlin speaking to, which is really common throughout the research study, almost word for word, children saying, I wasn't a person to you. I was just a number, another piece of paper. Now, that obviously, for those of us who've been involved in family court proceedings in very difficult cases, thinking in great depth about what the right outcome for a child might be, can seem quite surprising. But I think that's what this whole evidence base speaks to, and the input from the professionals and young people who are involved in the toolkit is recognising that just because that dialogue might be happening in court, that thoughtful consideration might be coming into court, that doesn't mean that the child's experiencing that unless you communicate it to him, hence that second purpose. Can we go on to the third? Next slide, please.
Having a letter would have given me more trust in the decision.
So this really comes from children and young people talking about the importance of trust, and talking about how being able to trust the judge and the decision-making process would help them accept the decisions that were made, even, as I've said, in those circumstances where it wasn't necessarily going to be the one they wanted. The judges who fed into this toolkit raised this particularly in relation to older children, recognising that for them, having that understanding and getting as close to you can as of acceptance of that decision can be really important, because actually that young person's willingness to go along with whatever arrangements the court has decided is in their best interest can actually be make or break. That for those older young people, you really do need to, as far as you possibly can, be making them feel like they are on the journey with you and that they are willing to go forwards with the plans that the court has decided on. Next slide, please.
When everything is high pressure and high emotion, it can be hard to remember things. Having a letter to look back on could have helped.
I think these letters are an important contribution to life story work because they provide the children with a narrative of what happened that they can incorporate into their broader life story. And, you know, we know that having a kind of clear story about what's happened to us in our lives, even if some of those things are painful and distressing, having a coherent story is generally associated with a better ability to understand yourself, understand what's happened to you, and regulate emotions and sort of be present in your life going forward.
So this purpose links back to much of what we were saying before about the importance of that understanding of what happened and why, but it also really engages with the sense of children as people who change and develop over time, and their understanding will change and develop as they learn and grow. So the Family Justice Young People's Board were particularly keen to stress how important it can be to have that moment in time captured, because even if you did receive an explanation at the time, it may be that as you grow, you've forgotten some of that, particularly in the context of that high pressure and high emotion as they describe it there, and having the letter to look back on could be helpful. But the other professionals involved in development of the toolkit also highlighted the potential importance of this for very young children involved in proceedings who won't be of an age at the time when decisions are made to engage with the letter, but who might be coming to understand what's happened in their life later down the line. And that's what Dr. Webb is talking about there, the value of these letters in the context of therapeutic life story work. Next slide, please. So the toolkit really stresses that every child is different, every situation is going to be different. And so there can't be this template letter that applies to all situations. And in fact, the young people were really clear that that is not what they want, because this is about engaging with them as an individual. But the toolkit does give some examples drawn from previous letters that judges have written to children of how you might approach thinking about different situations in public and in private law. And the three examples span those and also a range of ages for the children involved. It includes a list of things to think about when writing a letter, some top tips, and that includes top tips from some of the communications experts who were involved in supporting the development of the toolkit. So thinking about language, thinking on how you might draw in the expertise of the professional network to help you in your role as a judge, and also thinking about how you tailor it to those specific needs of the individual child. It also contains some links to further resources that people might find useful, including some of the published judgments for children and letters to children that already exist. So the toolkit is really aimed at aiding judges who are either undertaking this for the first time or who may have been doing it for many years. And I think that that's probably a good place to pass over to my judicial colleagues here to hear about their experiences.
Thank you so much, Jude, for that. That was really informative, and it was really fantastic actually to hear directly from the young people that are involved in developing this as well. So thank you. Just stop sharing your slides, and I'll take this opportunity to say to everybody who's joined, we do have hopefully the opportunity for some questions and answers with the panel later on in today's session. So please do use the Q&A function on Teams to pop a question in there. We will try and get to them. But whilst people are doing that, Judge Berger, Judge Entwistle, welcome. Thank you for joining us. And I hope you don't mind, but I've got a couple of queries or questions to get us started, if that's okay. So Judge Berger, you have very kindly agreed to join us today as a judge who's had experience of writing to children, and I was hoping you could just tell us a little bit more around your kind of motivations for doing this practice.
Well, thank you firstly, Sophie, for inviting me to be here today. I find it really quite sobering when I hear Caitlin, and I've heard that before, and I hear young people saying quite loudly and clearly through the research that they just don't feel heard. I hear that directly too. We've had reviews of some of our court practices here by young people, and those messages are still coming through now. But what I think the biggest motivation for me, coming from a background where I have worked with children and families for a very, very, very long time, is acknowledging that they have a right to participate in the process of what is going to happen to them. And acknowledging, as was said through some of the studies, that children want to communicate. Not all, but some children want to communicate with the court and with the judge. And when they do that, and when professionals tell me they've written a letter to me, acknowledging that input from the child and acknowledging what they've said and acknowledging to them directly, and I'll come to how I do that in a moment, how important what they have said is to the court and to the court's thinking about what should happen to them, I think is really very important. And I also think that years have taught me that one of the things children and young people want at the end of their case is a reassurance, actually, that it is the judge that made the decision. And I use letters and I use writing to children and I use my communication with children to make sure I emphasize, whether it's public or private law, that ultimately the decision was mine. And I think that's really quite important for some children who are in quite chaotic situations, who want someone who's stood back from it all to take responsibility, and for many children to take the responsibility off their shoulders about what should happen. So I'm really quite clear that those are the things that motivate me.
I think there's some really good points to raise there. And I was going to say, Judge Entwistle, what about for yourself? Is it kind of similar motivations, or has this been a practice that you feel you've always been doing? Or was you kind of encouraged to start at a later time?
Well, prior to the position I'm in now, I was a solicitor for children. So I had that role with children. And I think an understanding that children do feel quite isolated from the proceedings, although that was, to be fair, many years ago now. I think there were one or two triggers really. Increasingly in CAFCAS reports, in Guardian's reports, there will be a section which is a letter from the child, usually when the child is old enough to write. And I'd see that in final reports, and I would sort of be compelled almost to write back, because the child's taken the effort to write to me, the effort to say what their wishes and feelings might be, and I think it's important to correspond. And to be quite frank, I started to do that regularly. So if there is anything within the Guardian's report, if there's a letter that's been written by a child, I think it's essential to respond. And that's now developed really in terms of much younger children who perhaps can't communicate as well, ensuring that there's something at the end of the judgment to acknowledge, as Judge Berger says, it's my decision. These, very briefly and in a child-focused way, are the reasons for that decision, and to put that at the end of judgments in relation, for example, to placement orders and so forth. So I've always been worried that we don't engage children enough in proceedings. I think the catalyst was seeing children write in Guardian's reports, and that's just expanded really as time's gone on.
I just wanted to touch then on what you were saying around kind of young people feeling heard, feeling like they've been able to take part, feeling like, you know, is that judge that is finally making the decision, because they are all coming from their own kind of unique set of circumstances. And in Jude, your presentation, the young people were thinking who fed into the toolkit, they were sharing things around the importance of treating the children as individuals, really tailoring how you are responding to that. And I mean, you've started kind of alluding to that in that conversation then. So I was going to ask both of you, are there any particular examples around where you have kind of adapted it in terms of your practice, recognizing what a particular young person might have been through, and that's meant you've had to really rethink your approach? And I don't mind who takes that first.
I think my starting point, Sophie, is always trying to remember from the earliest point in the case, flagging, how is a young person going to be engaged in this? And I take the point that is made that, you know, guardians' reports have letters, but I also work in the real world where we know guardians and solicitors are pressured. And the practice, I think, that Matthew was describing was probably similar to my practice when I was representing. And I know that's changed. So for me, that question about engagement starts from the earliest stage. And it filters then through to my ultimate question at the end of a case, which is always about who is going to tell the child. And going back to context, I'm also aware, living in the real world that we are really quite pressured. And one of the beauties, I think, of the toolkit is that it highlights that this isn't just about writing letters. Actually, Matt again has alluded to it, there are really creative ways of explaining a decision to a young person. I take my lead, generally speaking, if there are particular circumstances for a child or a young person, usually from the professionals involved, particularly actually the child social worker, because if they've been around long enough, and some of them have, will have worked really quite closely with that child and young person. So I take my lead from them, and then I develop the way I'm going to communicate and what I'm going to say, whether that is a section of the judgment, whether actually it's an agreed note that is either recorded on the face of my order or recorded in some way so that it can be communicated to the young person. And I go through lots of different thinking, usually with the professionals, about how best to do this. I have to say that in my court, a practice has developed where professionals tell me really quite often that young people want to come and see me, and that children, younger children and groups of children prefer to come and see me, and I do that. I've never once said, no, that's not appropriate. I create the time, I find the time when suits them, and I see them. And I think for some children and young people, that actually is really quite effective. Particularly from the perspective of them seeing a judge that doesn't look like how they imagine their judge looked. For some children who are from the communities that I serve in Birmingham, it's really quite important that they see a judge that does look like them. So I think it's got to be individual, and it's got to be developed through constant discussion and asking. But if we keep in mind engagement and keep in mind who is going to tell the child at the conclusion, we can't go wrong. And those are two things that we can hang on to, and that are easy to hang on to as we develop the case and work with the parties involved.
You just saying that then as well, in terms of young people understanding what court looks like or who their judge actually looks like. You know, young people have so many stereotypes, don't they, around courts or family courts that they see from televisions and films. It just adds to that sense of fear and disconnection from the process as well. So I think that was a really helpful point there. Judge Entwistle, what about yourself? Was there anything else you wanted to add in around that?
Well, I think Judge Berger's said perhaps one of the most important things. Firstly, when you write to children, it's essential that letters are generic. But I have the advantage of, in the majority of cases, children, certainly who are older than 8, have the option of coming to see me at quite an early stage in proceedings. And that does make a huge difference in terms of their interpretation of your role, who you are, what the courtroom looks like, and provides that participation from a very early stage. that then makes it much easier from my perspective at the end of a case to ensure that a letter or a note isn't generic and relates to perhaps earlier conversations that we've had, allows you to have some sense of the child as an individual, to understand what their likes and dislikes are, and even hobbies. Just very quickly, anecdotally, for example, I saw a 14-year-old girl quite recently, well, not quite recently, quite some time ago, and she was having some real issues. She wasn't able to play her music because she didn't have a guitar. She talked to me at length about K-pop and K-pop Demon Hunters, which is something I know about, but maybe not a lot of people do. When it came to the end of proceedings, she made it clear that she didn't want to come back to court. I didn't say that personally, but she had sort of moved on. But I did write to her and she corresponded back. And knowing her and knowing about her, not necessarily taking that information from the professionals, but of course you can do, allowed me to write a letter. And I think I need to stress, the letters can be as long or as short as you want them to be, but I think in the top tips, it indicates keep it short, a paragraph or two, but ensure that you use the child's name. Try and get something in terms of the hobbies and so on and so forth. And she felt as though she had participated very much in the court process, and that there's been feedback in relation to children coming to see me earlier, and there's been feedback in relation to how we end. Children will come at the end or will write letters. Either makes a huge difference in terms of how the young person feels that they've been involved.
Can I just add to that, Sophie, in terms of individualising what we do as well? I mean, one example I have is I did a picture letter, and that was on the advice of the social worker because they said the young person concerned would benefit from it. And that actually got me, it made me think far more than anything I've ever written, because I'm not IT, I'm not very good with IT. I had to really think about the pictures. There had to be a picture of the judge, and so on. And I think it's just thinking that through, but using again the resources that we've got. So the social worker was key. I was able to send what I did. He was able to comment and tell me what I needed to change, and I was able to do that. And then also going back to the point again about how we change what we do for children and young people. Thinking about the case that Matthew has just explained. I had a young person who's actually much older than 14. He was near the edge of where we stopped being involved. But, I always hook into what the child's interest is. And he'd written mini novels. I mean, this lad was so creative. And he'd written mini novels. And so what I did was I said, can you ask him to send me, with the permission of everybody, can you ask him to send me one of his short novels? It was only very short. Read it. That became the thing that I was able to engage him in terms of my decisions about him and how I fitted that in to what he was good at and what he wanted to do. And so it does take some thinking, but actually we do have, in my view, the resources to help us with those more complicated scenarios.
Oh, thank you. They are both really, really good stories to kind of bring it to life. And you've been talking about the tips and the way the toolkit can provide that guidance and some of those examples, as well as that wider network around the family. But I was just wanting to ask, is there anything else that you think the toolkit gives in terms of being a helpful resource for other judges? I know, Judge Entwistle, you were part of designing it. So any thoughts or any extras you think would be worth mentioning?
Well, I think the first thing is there are example letters. There is nothing harder than simply having a blank sheet of paper and sort of thinking, right, I need to write to a child. Where do I start? How am I going to do this? So the fact that there are example letters, I think, is of great assistance. The top tips in terms of age-appropriate language and considering sort of cultural background, and ensuring, as I've already said, that you don't make the letter overly long, are useful tips. And as Carol said, I think on more than one occasion now, using the professionals around you, that makes a huge difference in terms of your understanding and I think requirements in terms of what that child needs. I think one of the biggest things is to realise that these are vulnerable children and they have been through a lot, irrespective really of the outcome of proceedings. But children are also resilient, and the last thing that children want is for not just a generic response, but a response that doesn't really tell them anything. You have to be honest with children, as Jude's slides have clearly indicated, and as Sheena indicated as well. You have to be honest with children. Sadly, things can't be sugar-coated, but what you've got to remember is that the child's been living in those circumstances, and the child is fully aware of those circumstances. So I think it's helpful to perhaps write a letter just as you normally would, and then break it down in terms of making it a little bit more age appropriate depending on the age of the child, ensuring that it isn't generic. Sometimes to do it backwards is perhaps a little easier.
And that's a really helpful top tip. Thank you very much there. It absolutely speaks to, Jude, what you were sharing and what Dr. Webb was sharing in terms of, for children, it's better to know, and they understand a significantly larger amount than we often give them credit for. They've been within it for such a long period of time. We've only really been there for a snapshot. I can see a couple of questions starting to come in. Please do not be shy. No one is going to bite. But before I go to them, Judge Berger, Judge Entwils, both of you are family drug and alcohol court judges. And Judge Berger, I know that you lead on the Pathfinder for Birmingham area as well. And I was just wondering how this work probably links into that role, or how it can support child involvement, participation, elevating their voice within private law as well.
In private law, I think we have a real advantage in Pathfinder. For those of you who are not yet sitting in Pathfinder courts, you will find it incredibly refreshing when you do. And the reason for that is we talk about child impact reports instead of Section 7 reports. And the child impact reports I get start with a picture of the child, their wishes and feelings, their understanding of what's going to be recommended and what they think about that. And I think that means that in terms of those proceedings, our immediate focus is shifted. It's shifted from statements and case management and so on to this is what this child or young person is saying they want. So it brings them into the courtroom in a very different way and dynamic to how we ordinarily deal with Section 7 reports a long way down the line. And it forces, I think, everybody to focus. But I also think in Pathfinder, we've been able to be creative about our thinking about this. In Birmingham and Solihull, we're talking about how we can expand the process of children and young people being seen and being told decisions, not just by judges, but by magistrates as well. And we're thinking about that and trying to learn from what's happening elsewhere, such as Wales. But we also include in our orders so that they act as memories and triggers for us. How is the child going to be engaged if they need to be? And who is going to tell the child the decision? And we include those in orders, even where, and we consider that, even where we're making orders that are on paper. So as judges and legal advisors, we're already thinking about, we've read the report, this is really an agreed outcome. How are we going to help the parties understand that somebody has got to communicate this to the child where that's relevant, and how are they going to do it. And again, so we're thinking about that, and we make sure our orders are tailored accordingly. And where we need to, I mean, I have private law cases where I look at the parents and I say, right, who's going to tell so-and-so about the child? And they both look at each other and say, we don't want to do it. And I remember a case in particular where the parties both were quite adamant they were not going to tell their 14-year-old. So I did it and got them in, got her, told her what we'd all, I'd decided, and then sent them all off to have cake and other things. I know it's not always as easy as that, but what I'm trying to say about Pathfinder is I think it gives us a little bit of space to really think about these issues, and the orders that we're using enable that to happen, so that children are getting a better experience of the process.
I think that actually speaks really well to a query that's just come in around asking, can the panel share some ideas for how you deliver the letters to the children, recognising there isn't always maybe a particular professional to pass on the letter, or that maybe we feel that parents might be in a role where they can't guarantee that's going to happen. So if there was anything else you wanted to add to that, please do. But I think that speaks really well to that question there. Thank you.
I think in relation to certainly public law proceedings, guardians usually have a final visit with the child. So my letters tend to go through the guardian. In private law proceedings, we don't have Pathfinder in Manchester at this point. But again, if there's a key social worker or a guardian involved, that's obviously the easiest way. If not, it can be quite difficult. It depends how divisive things are between the parents, and that then does take some thought, and whether or not parents will even give a letter or explain a letter in the circumstances can be quite a difficult judgment, and that's where it can become quite difficult sometimes to have the participation that you would want. That will change quite quickly over time, given that one would expect Pathfinder will be rolled out reasonably quickly. Just in relation to the participation court point, I'm currently running a trial, I think, as I've sort of alluded to, where I'm seeing children much earlier in proceedings, in public law proceedings certainly, and that's having a huge effect in terms of their involvement and their participation in proceedings. And they, I think, perhaps unsurprisingly, just want to know, I think, as we've said, that there's a human working, that you're a human being, and that you are just trying to work to try and ensure the best outcome. And that, I think, is the same in some respects in terms of FDAT. You sit down with parents and they realise that you are trying to do the best for them in terms of the challenges and the positivity that you can give them within the non-lawyer reviews. I think there are some similarities in terms of meeting children in that it allows a child to feel as though they have some ownership, even if it is that they're only seeing the judge, they're only seeing the courtroom, or they're receiving a letter from the judge to explain what's happened in their proceedings.
Thank you. Jude, I was just going to bring you in. I know that you've had the conversations with a lot of young people. Was there any other kind of recommendations or top tips around delivery of those letters that you can think of?
I mean, I think the first one is just to think about it and think about it early. And that goes back to the points that both judges have made about not leaving this until, you know, the end of the final hearing and someone goes, oh, who's going to tell the child? You know, trying to start this earlier, because it's not always going to be straightforward. But I do think it's really important in those kinds of private law cases, for example, that Judge Entwistle was talking about, to recognise that our difficulty on the court system side and thinking about how we're going to get that letter to that child is probably, you know, a drop in the ocean in that child's difficulty in understanding what is going on in their life. And going back to what Dr. Webb was saying about the importance of that narrative, of understanding what happened, about who made the decision, how your voice was heard. So I'm not saying that it's easy, but I think talking to the professionals involved in those more complicated cases, talking to the family, the parents or the other family members involved about their thoughts as well. I think treating each case as on its own merits and thinking through what's going to work for the child there, but also recognizing that if as professionals we're finding it hard to think about what the answer for this young person is, that's probably reflecting back to us some of the difficulty that that young person is experiencing in their life, and they might be the young people who most need this in terms of that neutral narrative is how some of the psychologists described it in the development of the toolkit. But I do think it is easier to find your way through those kinds of difficulties and to be creative and problem solving about it if you're not doing it at the very last minute when everyone is trying to run out of the door, when you've already run out of time, and when you've got, you know, your next case to think about. Because I do appreciate that the time element of this is a very significant challenge for judges, and there isn't a magic answer to that. The toolkit obviously provides some examples and top tips, as the judges were sharing, which is hopefully will help, as the president said, you know, get away from the blank page in his forward, but also making sure that wherever possible we're trying to think about it early to avoid the absolute crunch of time as much as we can in the reality of the pressures that the judiciary and all the professionals working across family justice are facing all the time.
Sophie, can I just share one other thing that I do, which is if I'm going to write, I often think, and it comes back to this point about not being fearful of saying what needs to be said, because actually children understand their lived experiences better than any of us, and often communicate it better than some of the professionals when they do. But I sometimes imagine what I would say if they were in front of me. How would I phrase it? What would I do? What would I focus on, and what would I talk about? And that then helps me to write something that I think they will appreciate and benefit from.
Oh, thank you. No, I think it is that element, like you've talked the whole way through in terms of relationships, but this also then links into a couple of the questions that are coming in as you've got creative and started to look at ways of building that child participation and communicating with the child. There's a couple of queries coming in around any recommended or any kind of guidance or advice around ending that relationship with the children and what that might look like. There's also been a query in terms of experiences around whether any of the correspondence has been challenging and needed to come to, or needed to be brought to a close or to a finish in terms of child participation and writing to children as well. So I don't know if either of you got kind of experience or wanted to speak to that.
I think in terms of bringing matters to a conclusion and ensuring that transfer, I think all you can do is to wish a child best for future, indicate that you hope that their placement or whatever it is something which gives them a safe and warm and comfortable environment. It is quite difficult. That there has to be an end point. Sometimes I think that actually it's probably easier to see a child at the end of proceedings than it is to write, and probably doesn't take more time in reality either. But it is quite difficult, and I think the example letters all sort of indicate, you know, I wish you the best of luck. I hope that you're safe and warm, and so on and so forth. And I think that is probably as much as you can do. In terms of issues around confidentiality and the letter being published and so on and so forth, that's not something that has happened in any letter that I've written. I think the letters aren't going to go into so much detail that there are issues in terms of them being published by the child, but I think we've got to have a level of trust in relation to what the child's going to do with the letter. The letter's for the benefit of the child. What I would say is that when I send a letter to a child, I do send it to all of the parties, certainly all of the legal representatives. And there are occasions where I'm particularly concerned about a child's vulnerabilities, where I will send it to the solicitor for the child, for the guardian to consider, or to the solicitor for the local authority for the key social worker to consider, to make sure there's nothing in there that's going to be triggering or going to create difficulties. And that is a technique that you can use. Often it comes back and says, no, that's fine. Sometimes there will be, well, perhaps if that sentence was put this way, or something of that nature.
Yeah, I'd endorse all of that. And I'd also say, look, there's nothing wrong with keeping letters short. I think that comes out of the toolkit as well.
Yeah.
They do not have to be that long. They just simply need to say what we need them to for the child to understand what we've done. So I think that is another lesson that certainly I picked up, and I was quite relieved to see that when I looked at the top tips. And also to say, look, the handbook, as I call it, the toolkit, it's there and it's really usable. You can open it. That top tips section is just brilliant for drawing your attention to the kind of key things that we know have been tested and we know that work. And so I use it now, and I'm really grateful for it after all these years of having represented children and young people and having sat. So I want to thank all those involved, really, in bringing it together.
And I think I'd echo that.
Including you, Matt.
Well, no. But I think the other thing is that when you talk about writing letters, you envisage finding that monogrammed letterhead paper that we have and writing it in a quill with an ink pot. You can send an email. But as long as it's personal, send an email via the children's solicitor. It does save some time, and that again is probably a time-saving technique and something that assists.
It is.
I'm going to jump in because I am very mindful of time, and I'm aware of colleagues potentially needing to go off to listings. But I have one question, if extra one, just if everyone is able to stay on for an extra minute, that there has been a question around and a statement around how relevant this discussion and this way of working is potentially for children within criminal court proceedings as well. And they were asking, is the panel aware of any of these discussions taking place to transfer this work into criminal court? So I can see Jude nodding. So if you are able to speak for a very short while, and then I'll wrap us up.
Yes, absolutely. And in fact, two of the academics who were involved in development of the toolkit have worked in across jurisdictions, both in terms of across family, immigration and crime, and also internationally, looking at the way in which we communicate directly with children, how that is a mechanism by which we uphold children's rights in all of those different contexts. So if you look in the toolkit, you will see references to that work, and I'd really encourage criminal colleagues to take a look at it, because where children and people describe that process of not feeling heard or understood, being part of this system that's kind of happening over here, and it's their life and they're on the outside of it, that's very in keeping with young people's descriptions of their experiences of criminal justice as well. So there is a lot of overlap and parallel, but actually I think some of the thinking about this, and particularly where young people are defendants, thinking about sentencing and how you communicate that to young people, is actually more developed. And we were really grateful to be able to develop some of the thinking from some of that thinking in the family work. So definitely for criminal colleagues, if you take a look at the references in the toolkit, I hope you'll find something useful.
Oh, thank you so much indeed, everybody. It's been a fantastic expert event today. I've really enjoyed the conversation. So thank you for giving up your lunchtime and your time for us today. We will make sure that the recording is sent out to everybody who has been signed up. And if you're interested in future events, please do sign up to the newsletters. I know links to this will be circulated as well. But I just wanted to finish by saying a huge thank you, Jude, Judge Entwistle, Judge Berger. It's been a real pleasure, and thank you for sharing your skills and knowledge with us today.
Thank you, everyone. Bye-bye.
Thank you, everyone.
Take care. Bye.
Bye-bye.
Thank you.